This is an abomination. This is an individual jurist who is uncomfortable with the Second Amendment and is now going to use some degree of intellectual sophistry in order to deny law-abiding citizens their ability to defend themselves. This is exactly why we have the Second Amendment in the most broadest contexts as possible. Today, we're going to be discussing a development that's taken place in New York in the case of Goldstein v. Hochul. And I'll be quite honest with you, it's annoying, all right? So a little bit about this particular case. As many of you are aware, immediately following the Bruen decision, the New York legislature went into overdrive. They wanted to try to pass as much of a restrictive form of legislation as they could, acknowledging that they had to give concealed weapons permits to their citizens. Now, they wanted to try and deny as many locations as humanly possible of where their citizens could actually exercise their constitutional rights and bear arms. One of the locations that they decided they were going to prohibit individuals from bearing arms were in places of worship, all right, synagogues and churches and the like. Hey guys, this video is being sponsored by USCCA, and they're doing a giveaway. Now, it's going to end soon. It's very, very cool. I definitely encourage you to look at the description below where you can find out more information about it. What they're giving away, you're going to want to participate in. I can give you a hint. It fits in your holster. Initially, it was just a blanket prohibition. No one under any circumstances could bear arms inside a house of worship. They later amended the statute to say that security guards could bear arms inside of a house of worship if they were obviously contracted by the house of worship itself. That being said, this law is being challenged, and Mr. Goldstein, along with several other plaintiffs, have sued, saying that it violates their constitutional rights, which in my opinion, it absolutely does. So they moved for a preliminary injunction to prohibit the enforcement of this right. Now, they originally moved for a temporary restraining order. That was denied by Judge Vernon Brodericks, a U.S. District Court judge, where this case is being litigated. They then moved forward to ask for a preliminary injunction. Now, in New York, for a preliminary injunction to be issued, the plaintiffs have to show that they were going to suffer an irreparable harm. They need to show that they have a high likelihood on the merits of prevailing. And then there's this interesting interest balancing test that the court has to engage in to decide whether or not the interests of the state, outweigh the interests of the individual. Again, this is just for the issuance of a preliminary injunction. Well, Mr. Brodericks, or rather Judge Brodericks, has issued his opinion on the preliminary injunction, and he denied it. Now, what's interesting in his opinion, he goes through and does a Second Amendment analysis. He looks at the Bruen decision. He also pretty much tells you exactly how he feels about the Bruen decision in a footnote that's present on page 27, which we'll go over here in a little bit. Now, again, this isn't a final ruling of the merits, but as I've mentioned before in other videos, when a judge either grants a preliminary injunction or denies a preliminary injunction, they have to go through an analysis as to whether or not the plaintiffs are in fact going to prevail. So it's a pretty big tell on how this is actually going to go down. Now, those of you who have listened to videos on the Bruen decision already know that the threshold question that the plaintiffs have to show is that the Second Amendment actually is, controls this conduct, that their Second Amendment rights are being violated, or at the very least being abrogated by this particular statute. Once they've shown that there is this nexus with the Second Amendment, then the burden shifts to the defendants, and the defendants have to show, that in this case, the state has to show how the statute is consistent with our nation's history of firearm regulations, specific to the time of the ratification in 1791. Now, there is a possibility that it also would be consistent with the regulations that existed in 1868 at the ratification of the 14th Amendment. There is a legitimate legal argument that that is in fact factually inaccurate, that it's exclusive to 1791. And there has been a recent Supreme Court case called Espinoza versus Montana, which sort of reinforces this principle. That being said, within the Second Amendment jurisprudential community, there still is this belief that we look first at 1791, and then we can look at 1868 as long as laws that existed in 1868 are either similar or analogous to the laws that existed in 1791. If they're contradictory, 1791 controls. So laws that exist outside this time frame have really no dispositive value. So if a judge were to look at a law that existed in, say, 1953, that's brand new, that would have absolutely no relevance to whether or not a statute is in fact unconstitutional. So Judge Brodericks, wanting to ensure that houses of worship can, still be regulated, goes through this ridiculous intellectual gymnastic to essentially say that it's absolutely consistent with our history and regulatory traditions of banning guns or weapons at houses of worship. Now, do want to talk a little bit about the plaintiffs here. So these are individual plaintiffs that have actually had concealed weapons permits for a fairly substantial period of time, pre-Bruen. And they are deeply religious and observant Orthodox Jews. They go to temple a lot. And when they go to temple, they carry their guns. Many of you, hopefully, are aware of the fact that there are a number of individuals that are out there that bear a fairly high level of animosity towards people of the Jewish tradition. And as a result, they need to be able to protect themselves, not just within the synagogue itself, but going to and from the synagogue. Well, a new prohibition against carrying a firearm in a temple is going to preclude them from going to the temple in the first place, which violates their ability to exercise their freedom of religion. So in their moving papers, they claim that not only has the Second Amendment been implicated as a result of this, but also their First Amendment rights as well as their 14th Amendment rights. There's a series of things that they're challenging. Now, in this video, we're not going to talk about their equal protection claims or their First Amendment claims. They're legit as far as I'm concerned, but the focus that I want to, kind of relegate ourselves towards here is the judge's refusal to essentially utilize the test as established in Bruen. Now, just a minute ago, I referenced a footnote, a fairly extensive footnote that the judge writes on page 27. And I think it's instructive if we just read this out loud. Some courts, legal scholars, and historians have questioned the logic of limiting Second Amendment analysis such that it focuses nearly exclusively on history. I note but do not address in detail the weakness inherent in reliance on history to circumscribe the scope of the Second Amendment, such that the fact that judges are not historians, the dangerous potential for historical examples to be cherry-picked and the historical record to be distorted to bolster a particular viewpoint, and the practical difficulty of resolving complex historical questions, especially when a written historical record is anecdotal, incomplete, or inaccessible. I am concerned about relying solely on looking to historical statutes and regulations from 1791 and 1868 to determine the breadth of the Second Amendment. All right, so he goes on. It gets a little bit more detailed. But we need to talk about what a court actually is, okay? At its most fundamental level, a court is a trier of fact. When you think about a court, when you think about a trial, think about it in terms of a laboratory, a location where scientific experiments are being conducted. Every single time a litigant comes into a courtroom, they come into court with evidence. Now, some evidence is better than other evidence, okay? That's just by the nature of the beast. And that evidence is looked at, it's analyzed, it's scrutinized, it's tested not only against basic tenets of common sense, but it's also tested based on other evidence that's been brought forth. Typically a jury, although in this particular case a judge, will look at evidence and start assigning dispositive weight to that evidence. This is, by the way, one of the reasons why people get so frustrated when they hear that evidence is being excluded at a trial, right? They'll hear in the news that such and such a thing is being prevented from being introduced at trial. There are reasons for that. We have very, very extensive rules of evidence to ensure that that little evidentiary packet that's being brought into trial has effectively been sterilized from all of the extraneous things that could go around it that would make somebody not look at it properly. Again, think of it as a sterile laboratory. We look at the evidence stripped of all the emotions and everything else, and then we analyze that. Now, if there are competing viewpoints, if I bring in a historical record that says that in 1791, X existed, and the opposing counsel brings in a historical record that says in 1791, Y existed, well, now we have two disparate ideas, right? And we now have to challenge each other's evidence by looking at the intellectual weight of perhaps who drafted this historical document, the number of other historical scholars that agree with one position versus another position. This gives a certain level of weight. I mean, after all, if I bring in 27 examples on the historical record of one thing, and the prosecution or the state brings in, say, one historical example that was written by a politically motivated historian, and we've got a lot of evidence that can be shown that they are, in fact, a politically motivated historian seeking a particular outcome, my 27 pieces of evidence are going to be far more dispositive than that one piece of evidence. Now, like I said, in 1791, there were not a tremendous amount of gun regulations that existed. There were some, but there weren't a tremendous amount. And this is the thing that bothers judges. They're not upset. They're not concerned about the historical record having to be analyzed, that judges are not historians. That's crap. Most judges, frankly, are historians. That's one of the reasons why we got into this gig, because we love history, okay? They are upset about the fact that if they rely on the historical record, they're not going to get the outcome that they're hoping to achieve. That's what it really comes down to. Now, when it comes to sensitive locations, and that's what we're specifically discussing here in this challenge to New York's law, when it comes to historical, sensitive locations, Justice Thomas in Bruen, essentially maintaining the same line of argument that existed in Heller, said that there can be sensitive locations, right? There were certain sensitive locations at the time of the ratification. Specifically, he cites courthouses and polling locations. Now, the argument that they would prohibit the carriage of arms in a polling place and in a courthouse is that these are locations where it can be assumed there will be inflamed passions. Obviously, in a courthouse, there's always going to be a losing litigant. And in polling locations, there's political factions that gather around them. And as a result of that, at the time of the ratifications, we did, in fact, restrict the carriage of arms in those very specific locations. A synagogue is not typically a location where you are going to find inflamed passions. All right, should be obvious. All right, so as a result, the judge, looking for an outcome, essentially said, I'm supposed to look just at those laws that existed in 1791, maybe 1868. But you know what? I'm going to look at the laws going all the way up to the 1940s, okay? Because you know what? I kind of want to, right? Because I'm not getting what I really want from the laws that existed back then. Again, it's intellectual gymnastics that are based on an outcome determinative proposition. It's unbelievably troublesome. All right, now I'm going to tell you, I have personal reasons for being as upset with this as I am. Some of you may be well aware of this. About a year ago, a very, very close friend of mine, a student of mine actually, he was a member here at the Artemis Defense Institute and trained for years with us. His name was Dr. John Chang. Dr. Chang was a true master at skill at arms. He was a concealed carry permit holder, and he was, like I said, a personal friend. He also happened to be my wife's doctor. In fact, he was actually the doctor that signed off on my daughter going to West Point, all right? So like I said, on top of simply being a student of mine, he was a close friend of mine. He was also very deeply religious. His mother was not, and his mother had lost her husband, John's stepfather. She was despondent, and he was trying to encourage her to go to church. Now, the family came from Taiwan. Dr. Chang was actually born in Texas, but his family originally emigrated here from Taiwan. Anyways, his mother, while she wasn't terribly religious, did find out that there was going to be a visiting pastor who was somewhat of a political pastor who was going to be speaking against forced mainland Chinese reunification with Taiwan and his antagonistic feelings about that at a church here in Southern California called Geneva Presbyterian. This was not Dr. Chang's church, but since his mother showed some interest in going, he was thrilled, absolutely was going to take her. Now, this particular Sunday, John was actually going to be taking a class with us at the range. When his mom showed interest in going to this sermon, he canceled the class and instead chose to take her to this Geneva Presbyterian Church. There was an individual, interestingly enough, a security guard from Las Vegas, 300 miles away, who was very antagonistic towards the Taiwanese community. He was actually from mainland China. And he decided that he was going to assassinate this pastor. I guess on his drive from Las Vegas to Laguna Woods, he decided he would extend that and try to kill as many people in the congregation as possible. Now, for reasons that we will never entirely know, Dr. Chang chose not to bring his weapon with him that day to the church. It could be that he just chose not to carry. It could be that he felt uncomfortable carrying a gun into another house of worship. We just will never know. What we do know is that this piece of garbage decided to start shooting people inside the church. Dr. Chang realizing what was taking place, rushed the shooter and ended up suffering a mortal wound in the middle of his counterattack. Dr. Chang, knowing that he had been shot, continued to press on with his attack, eventually tackling the shooter to the ground, and this inspired the rest of the congregation to then pile on. Only one person that day lost their life, and it was my good friend, Dr. Chang. There is no conceivable way that Dr. Chang or anyone in that church could have thought that a politically inspired criminal from Las Vegas would travel all the way to Southern California to commit this act of atrocity in this church. The point is that Mr. Goldstein and his fellow congregants in the synagogue in New York are living under a credible threat. It's not just against the Jewish community, it's against anyone that would seek to do a religious congregation harm. All right, and not being able to possess a firearm can lead to the same conclusion that happened with Dr. Chang in Geneva Presbyterian. This is an abomination. Now, I use that in a religious connotation, of course, but it really is. This is an individual jurist who is uncomfortable with the Second Amendment and is now going to use some degree of intellectual sophistry in order to deny law-abiding citizens their ability to defend themselves. This is exactly why we have the Second Amendment in the most broadest contexts as possible. Anyways, I do encourage you to follow this decision or this court case. We'll have to see where it ultimately goes. Of course, you can always contact me at steven@artemishq.com. And again, as always, train constantly, train consistently, train repetitively, and train with purpose.
Before you go, you just missed one of our best videos that got over 500,000 views. Click right here to watch it now.